which was in the possession of his lover.
You want to? I'll let you go.
Oh, I'm sorry.
No, I'll let you go.
I don't have my rule book
No,
today.
I know you don't have one at all.
I'm not.
And maybe you got to figure out who does.
I understand. I'm sorry. Get a little
To hear the matters. Court does call the case of the People's State of Michigan versus Thomas Gay.
Ashley Phelps for the people.
Are you sure, or are you just? Is he in custody?
No, no.
Does he want to be? Oh no.
Oh,
What?
does he want to be?
I was just asking.
State your name for a quick, please.
Thomas Gay. Thank you, sir.
Your Honor, we're going to ask for an adjournment. The prior prosecutor and Mr. Cook and I were in discussion about whether this was resolved or not. It looks like there's still some investigation going on. And
All right.
I will submit a green form.
You don't have one with you at this point. All right. Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond will continue. Thank you.
December 22nd. 11, thank you.
I got one.
11.
I got it right. That's what I was saying.
Oh, you get it right. I guess we'll applaud.
Would you please?
No, you got it. Court does call the case. People versus Samuel, Forbes, Allen, Dabney.
People. Assistant Public Defender Sandra on behalf of Samuel Allen Dabney. Your Honor, there's been a retained counsel. May I go get him? I believe he's in the hallway.
Oh, was he?
Good one, Judge. Attorney Chair Richard Defendant, we have Mr. Allen Dabney. P number is 42028.
Okay. Good morning.
Good morning.
Your name, sir?
Samuel Allen Dabney.
All right. Yeah, it's my understanding that the people are asking for an adjournment.
Okay, that looked like a shock. All right.
Well,
Well, no, hey.
you told me 2 minutes ago. Is that?
You'd want to adjourn.
I believe the fence is asking
Okay.
for an
Well,
adjournment.
no, I'm not. I don't.
It's funny that Miss White is standing up there, not in the middle of the mess. Go ahead.
It's not
For
a mess.
once, I
For
know.
what?
For once.
I'm going to be asking for a preliminary examination, so I don't really need an adjournment. I just need the discovery.
Well, I don't set a preliminary examination until you have to discover.
Okay, well, there you go. So I need an adjournment then.
Okay. Took us a while to get there, but we got there. You want the 4th or the 11th? Then?
Since the 4th is my birthday, I'm going to take the 11th.
And I'll set it for the 4th. December 11th, 2025, 9 a.m. Bond will continue.
And I would like to speak
And
to.
I would just wish you happy birthday, but now you're
Thank
going to
you.
ruin that.
I like
Go
to
ahead.
speak to the matter of bond, Judge.
Yes, sir.
Your Honor, my client is 26 years old, no prior history, no prior felonies. He's had one DUI that was like 7 years ago, and that is the only thing that is on his record. This incident stemmed from a matter that happened back in February, January. There was in Canton. This stems from a situation that happened in Canton. My client cooperated fully with the authorities back then. When I say fully, I mean fully. He resided at the same place that when he was arrested back in February, where he got arrested, when he was arrested a couple of weeks ago. In July, when he tried to get some of his phone, his laptop back from the authorities in July, the officer told him then that they were still trying to investigate and charge him with the crime. He still didn't try to flee I'm trying to get to the point that he knew that this something may be coming down the pike, but he still resided at the same location and didn't try to flee or anything. I believe the bond currently is $500,000, which might as well be $5 million. I would respectfully ask the court, based upon his non-criminal history and the fact that he did not try to flee, even though he was arrested back in February, was held for a few days. Is that correct? 3 days, fully cooperated with the authorities, then gave statements and everything. And a few months passed. And when he got his phone back, or went to try to get his license from the police officers, the detective, they said, "Hey, we're still investigating. They're trying to charge you with this." Still resided at the same location. When they arrested him, he was at the same location. I would respectfully ask the court to give a more reasonable bond. I know the charges are serious. However, if Mr. Dabney would have wanted to flee, he could have done so for the past 7 months, Judge. He could be in Tahiti right now.
Does he have other felonies pending?
No, Judge.
No.
No.
Okay. Respond.
Your Honor, I would object. It's my understanding from Mr. Kennedy, as I'm covering this case from today, is that at the next PCC, it's our intention to amend the complaint to amend the charges and add charges of aggravated CCM possession using a computer to commit a crime, as well as CCM possession. In this case, it does stem from an incident in Canton where authorities were investigating a different individual. And in that investigation of that individual, they found a video on that individual's phone that had been produced in his basement with an individual on a video who resembles Mr. Alan Dabney sexually assaulting a child. Through that, they got his phone for this investigation and located an overwhelming amount of CCM on his device.
On Mr.
Yes, and those images include images of children performing sex acts on each other, as well as being sexually assaulted by adults, as well as nude photos. And the report only just gives a small, I guess, preview of that. The report states overwhelming amount of CCM on his device. So I have extreme concerns given that he was investigated for a video of him sexually assaulting a child, which then led to.
You honestly, now I like to hold on.
Well,
She just indicated it
you
resembled.
need to not interrupt. She
Okay.
did not interrupt you.
She just.
No, what did I say?
I understand, Judge.
Go ahead, miss.
And then now they find all these other images and videos on his phone. So I have concerns, would ask that bond remain as set.
What I would like to object to was she indicated it resembles. They had 9 months to determine whether or not this was in fact that a person on the video. And now she's saying resembles. And then 2 minutes later, she said, it is him? I object to that mischaracterization, Judge.
And it was led to him, and then there's CSAM on his phone.
And just as I know it may not matter, but Mr. Alan Dabney was involved with this man in a romantic relationship, and this man that they found the devices, he had possession of his devices, of my client's devices. Sharik Alam, this person stayed in Canton. The authorities was led to this other individual's location. My client was involved romantically with this person that they arrested and charged back in Canton in February. As I already indicated, I understand that the charges are serious, but what I really do not like is that when she says resembles, that means that they don't know if it's him or not. And for the past
Maybe
7
that's
months.
the purpose of these proceedings.
I understand, but I don't like the fact that she said resembles and then says it's him.
That led to him, as I'm to understand, and that.
Yes, I'll correct what I said. If the report says resembles, we have to talk with Detective Morrison further to see what that video actually entailed, as it was just the first part of the report. So I'll correct what I originally stated. But that video did lead to them getting Mr. Alan Dabney's phone and locating voluminous amounts of CSAM on his device.
Anything further?
No, Judge. I just think that a more reasonable bond in this circumstance with no prior criminal history would be more like 100,000, 10%, Your Honor.
Well, given that if it was that individual, but then led to CSAM, which was on his device,
Which was in the possession of his lover.
you want to, I'll let you go.
Oh, I'm sorry.
No, I'll let you go.
I don't have my
Counsel.
rule book
No,
today.
I know you don't have one at all.
I'm not.
And maybe you ought to figure out who does.
I understand. I'm sorry. Get a little excited.
Because this is going to be a long hearing.
No disrespect, Judge. No
Well, it
disrespect.
was.
Okay.
given everything that the court has heard, and further that there are additional charges, which I understand are coming in the case, the court does believe that the bond as set is appropriate. Motion for bond reduction is denied. Bond will continue.
Thank you.
Your Honor, just briefly, may I just respectfully ask for the 10% or no?
Bond will continue as set. Thank you.
Thank you.